Welcome to Talking Beats with Daniel Lalchuk. That's me, and I'm so glad you're here. If you like what we do, I'd love it if you gave us a 5-star rating on Apple Podcasts or wherever you listen. And if you're so compelled, write a review. That really helps, and maybe tell a friend or family member. They might like the show as much as you do. If you want to get involved in the program, visit our website, talkingbeats.com, and click Support the Show, where you can make either a one-time or a recurring donation. As we look to continue having cliche-free conversations of real substance with a diverse range of the world's most compelling people, your support is so appreciated, especially as we look to expand and increase our offerings. If you have a question, comment, or thought, find us on social media, Instagram, Twitter, and Facebook, or if you wish to reach out directly, email me at daniel@talkingbeats.com. I'm so glad you're here. Let's get on with today's conversation. On today's program, we're talking Supreme Court and the recently concluded term. There were lots of major decisions this term, including rulings having to do with voting rights, donor disclosures, students' First Amendment rights. Remember that strange case from Pennsylvania where a young woman didn't make the cheerleading team, posted on Snapchat later on, and was admonished by her school. Union access to workplaces. Student athletes are talking about the NCAA ruling and more, including the Affordable Care Act. Here to give us a guided tour, Rorie Solberg, professor of political science at Oregon State University and expert in American constitutional law and the judicial process, and Nancy Maveety, chair of political science at Tulane University. I'm pleased they're both here and are going to offer us their expertise. Rorie Solberg, welcome to Talking Beats.
Thank you, Daniel. Thank you for having me again.
And Nancy Maveety, welcome to you, I think, for the 4th time. It's great to speak with you.
Thanks very much. I'm looking forward to our conversation today.
I'm looking forward to it as well. So there's a lot to look into here from this last term on the Supreme Court. On the one hand, we have more unanimous opinions than in the past 7 years, which is quite striking, as we've been hearing reports of the conservative wing cementing their ironclad grip on the court. Also, some very odd pairings in terms of who sided with whom. For example, there was a case where 5-4, Clarence Thomas joined the liberals. There was another case in which the 3 dissenting were Amy Coney Barrett, Sotomayor, and Kagan. Another one in which Gorsuch, Thomas, and Kagan formed dissent. So there was some odd pairings here. Rorie Solberg, what do you make overall as you look back at this last term at the court? Was this centrist? Was this an odd alliances? What was happening here?
Well, first, I'd like to say that, the odd pairings, I don't think we should make too much of those. And they've always sort of happened. They don't happen right on those big name cases, usually. But I think it's a mistake to think that the court is constantly going to be split down ideological lines. Because depending on what issue they're deciding, there may not really be an ideological position if they're deciding based on some kind of Article 3 justiciability requirement. You might see sort of those odd pairings there. Second, I know a lot has been made of the unanimous cases, but I think we want to look at that a little bit more carefully because they were only fully unanimous in about 18% of the cases, which is actually pretty low. It's a little bit higher than October term 19, but not actually less, much less, quite a bit less than the previous about 10 terms in terms of fully unanimous cases. So that big number people are quoting is really talking about unanimous in the vote, not necessarily on the opinion. And those are really different things.
Nancy Maveety, are you going to burst the bubble of optimism in that way?
Well, probably not, Daniel. I mean, I think what my colleague is suggesting is that some of these odd alliances that you're talking about probably reflect the nature of the question before the court, that it's some sort of technical statutory question, and not necessarily a decision where there are large policy implications. And I think when I look at this past term, what I see is sort of two parallel directions, two things happening. And it's quite possible that both of those things will continue to happen simultaneously. So here's what I see. One thing that is very clear, that was certainly clear on the last day of the term with the decisions that were announced, is that there is a strong 6-member conservative bloc that will align and does align around certain policy questions. And I'm referring to the two cases that technically, I guess you could say, both have to do with issues of political representation. One was, of course, about the interpretation of the Voting Rights Act, and the other had to do with disclosure requirements for contributors to charities, and that has implications for campaign finance. In both of those rulings, we saw the power of the conservative majority on the court, and I would expect to see more of that in other types of cases. So that's one simultaneous direction, or excuse me, one direction that I see happening, and I think it's reality. The other thing, though, that is also happening is interesting maneuvering within the conservative coalition around, I think, the question of incrementalism versus bold or engaged judicial action. And so one thing that is apparent is that there are differences, despite there being united around certain policy questions. I think there are differences among the Republican-appointed justices about how to address or how to get to certain policy results. And I'm speaking really of that trio that some might call the centrist conservatives, led by the Chief Justice, but seemingly accompanied, by Kavanaugh and Coney Barrett. Although, again, we have to be cautious, particularly a justice's first term is not necessarily indicative of where they're going to go ultimately. But that's something else that I think was apparent this term. You saw their force as a group in modifying certain decisions or modifying certain results, and sometimes gaining the support of the more liberal justices. So, sorry to go on so long. Those are the things that strike me when I think about, and when I would talk about this with my students. Those are some things I would point out to them.
Mm-hmm. And indeed, Adam Winkler from UCLA wrote, quoting here, perhaps most notably, this term revealed new ideological divides among the conservatives themselves. This is what you're talking about. Nancy Maveety, he writes, whereas Alito, Justice Clarence Thomas, and Justice Neil M. Gorsuch often urged the court to drastically and rapidly shift the law in a conservative direction, Roberts and Justice Brett Kavanaugh appeared to want to move at a more incremental pace. It's too early to know where Barrett fits in. Rorie Solberg, do you agree with that? Do you agree with what Nancy's just been saying, that there are gradations here among the 6 conservatives, but certainly when they wish to, they can band together and obviously control what happens?
Yeah, I think Nancy is absolutely correct in both of those directions, in the sense that I think we have seen the splintering of that, what it means to be conservative, just as we've seen it on the political spectrum in the elected offices, that, as this movement has grown, as we've gotten more and more conservatives on the bench in the law, right, it's been harder to keep sort of a monolith on exactly what conservatism means or what originalism might mean. And so you've seen some of those splits where Gorsuch will use originalism, as will Alito and Thomas, and they come to very different interpretations of what a statute or the Constitution might mean. So I think that is, very evident here, that even though you have your majority, that doesn't mean you're going to, be marching lockstep on each issue. depending on again, how they approach that originalism. And I think the incrementalism point is also really very clear and has been made by a lot of people. The other thing I would add to that, though, is that while a lot of focus has been on the fact that now Chief Justice Roberts has sort of moved out of the swing seat, I don't think we should forget about the importance of his position still, right? If he acts strategically, which I think he definitely has been, to stay in the majority, he gets to then, assign those opinions. So it's not just that he and Kavanaugh seem to be more incrementalist, but he also gets to assign those opinions where he might not want the law pushed as far to himself or to Kavanaugh, or perhaps Barrett, depending on, again, how she develops on the court, to ensure that even if he has his majority, that the opinion of the court reflects that more restrained view versus the sort of, boldly go view that we have from Alito or Thomas.
Indeed, just an interesting note about writing majorities, that the Van Buren versus the United States, this was the first time ever in which Justice Breyer was able to assign a majority opinion, and he could have written it, but instead he assigned it to Amy Coney Barrett. Just a little interesting point of trivia there, because as has been explained on here before, the assigning of the opinions goes in order of seniority, which you just alluded to. But
provided that the Chief Justice isn't in the majority, then the most senior justice will assign.
And some I think there's a misconception that the Chief Justice decides all the time who's going to write the opinion, and that's not the case, in fact.
Right. But again, if the Chief Justice votes fairly strategically to remain in the majority most of the time, he will keep control of that assignment power.
It's interesting because you wonder how much of that weighs on his mind. Of course, no one can go inside Chief Justice Roberts' brain and figure it out, but you wonder how much must depend on the case, how much weighs on his mind, whether to sacrifice something he really might believe in or believe is true to be for the sake of being able to assign that opinion.
Right.
That reminds me of the Berger court era.
Exactly.
Where Warren Berger was actually, I don't want to say vilified, but some of his colleagues didn't care for the rather ham-handed way he approached his strategic assigning power, and didn't seem to be acting in good faith sometimes with his strategizing in order to assign the opinion. I am not saying that is true about Roberts at all, but there is a dynamic on collegial courts and really in any collegial decision-making body whereby, one can manipulate the rules, use them for one's decisional advantage, but there has to be a modification of that so that it doesn't look like, just utter instrumentalism. And that's particularly true among judges. That sort of behavior would be frowned on for sure. But the other thing that Rorie's comment makes me think of is the other power, of course, that the chief has when he is in the majority is to choose to assign the opinion to someone who will write a big, broad, bold decision. And thus, the Voting Rights Act case was assigned to Alito, who wrote more broadly, perhaps, than he needed to in enunciating the position that we know is Roberts' position with respect to the Voting Rights Act and the desire to limit its breadth and its reach and the desire to balance interests of states against the federal government, along with perhaps what might be other aspects of a conservative agenda. Roberts there did not assign it to himself or assign it to someone who would write narrowly. He assigned it to Alito. And you know what you're getting with Samuel Alito when you assign him an opinion.
Mm-hmm. Right.
And this is the case in Arizona, Brunovich versus Democratic National Committee. The court ruled that Arizona's restrictions on voting in the wrong precinct is lawful and that the state can forbid voters from relying on another person to collect and drop off ballots. And that was 6-3, the conservatives making up the majority.
Right.
Rorie, you're going to say something.
I was going to say that while, what we know about the Berger court did show, as Nancy mentioned, that Berger was sort of ham-handed. In fact, I think some of the papers from the justices show that what Berger would do was something along the lines of be in the minority during conference and then assign the opinion and then say, no, I was in the majority, and kind of backtrack it that way. There's no ideological dissonance to have Roberts in those majorities, right? It's not surprising he would agree. Maybe not with the, again, full-blooded, full-bodied, bold movement that some of the justices want, but to be on that side wouldn't be considered disingenuous, I think, at all. You don't see him sort of flip-flopping in that way. So I think he can be strategic in opinion assignment and sincere in vote and still sort of, again, help keep the court restrained as much as possible. He's also, in as the Chief Justice, is supposed to allow for everyone to write the same number of opinions to the degree possible. And he's done a very good job with that as well. So he's, he can't not provide someone an opportunity when they're in the majority, but he's going to have lots of opportunities to assign to Alito or Thomas, much more so than, say, Sotomayor or Kagan. And so, as Nancy pointed out, right, he can be strategic where he wants to boldly go forward and move in that bigger direction on issues that have concern to him. He can assign to those justices. And then when he's wanting to, when he's thinking more about the legitimacy of the court or the legitimacy of precedent and the law, sort of move towards that more incremental approach. So he's got a lot of ability with the 6-3 majority to stay in the majority and keep control of that opinion assignment.
Let's talk surprises for a minute. So do you think there were more surprises or more non-surprises? Were there more surprises or more things that you sort of could predict coming down the pike as you look back at some of the major cases? We had, of course, the voting rights. We had the disclosure of charities from California, from San Francisco. We had the free speech case in which the cheerleader had very interesting case I found in which a young woman had not made the varsity cheerleading team, and she had taken to Snapchat, which is a form of social media, to complain about her school and complain about the result of not making the team. And she was admonished and she was punished. And the Supreme Court ruled that this was not right. This was unlawful of the school to punish her for speech that occurred off school property that was expressed via social media, that it was her right to do so. What does surprise you? You look at, there's quite a few other cases too, some very interesting ones.
For me, I think one of the more surprising decisions, I don't think was I think it's the Mahoney, the cheerleader case. I thought the unanimity in the Fulton case was fairly surprising. Fulton was the case out of Philadelphia where Philadelphia was not allowing religious organizations to contract to essentially contract for foster services because of their anti-discrimination law, because they wouldn't contract with same-sex couples. And I think we ended up with a unanimous decision because Roberts, again, with the opinion assignment, wrote such a narrow opinion that for the more liberal justices, it was strategic for them, I think, to agree, because that narrow opinion allowed Oregon v. Smith to remain on the books, at least for maybe one more term, which is to their benefit. But I think that was pretty surprising when that came down in a unanimous on the vote, if not unanimous on the opinion.
Nancy Maveety, doesn't it surprise you that in a case like this, when you're talking about same-sex couples and a Catholic adoption agency, city of Philadelphia, that you'd have the liberal bloc going right along saying, indeed, the city of Philadelphia did violate the First Amendment when it required a Catholic agency to work with same-sex couples. It seems quite surprising to me, no, to have the liberals going along there.
Yeah, I mean, the case is kind of a technical case in a way, or it was made into a technical case
I think that's it.
by the way the court's opinion was written. And so it offered, I think, refuge for the more liberal justices to say, all right, we can go along with this very limited way of looking at how a state allocates exceptions to some of its broad blanket provisions. And, this has really been kind of the trend and the tendency in the way free exercise cases have been developing over the last little while. I think there's certainly an effort on the Roberts Court to expand the scope of the protection of free exercise of religion. There is no question that is a policy interest of the conservatives and of the current Republican Party, right? I mean, that is clear. But I think what was happening in this particular case was a way of finding a narrow way to balance the interests of, again, free exercise interests, religious freedom, against certain other public concerns or certain other rights concerns, such as protection against discrimination.
Right.
And
right.
that's why the case came out, the vote came out the way it did. And so the opinion has to be read very carefully, because what it doesn't say is as important as what it does say. And of course, it inspired a very, what's the adjective I want to use here?
Vociferous?
A complaint from, again, Justice Alito, who's getting a lot of airtime today, isn't he? Basically accusing Roberts of, I don't know about duplicitousness, but accusing him of, not really going as far as he should have. That this was an opinion written on disappearing ink was I think the phrase he used. That It's such a narrow grounds. It provides no guidance. It has no meaning. It's just a way to fend off, a larger battle that's coming anyway. And again, there was a dynamic among the conservatives about whether they needed to revisit the precedent that was at hand. And I don't know how deep in the weeds you want to go on this, but in any case, that was certainly surprising. Yeah. Although I have to say, I was a little surprised about the cheerleader too. I wasn't expecting, although these conservatives love freedom of speech.
Right. They really do love freedom of speech, and they don't want to set a precedent that would, expand the reach of the state any further, right? By expanding the reach of the state into your social media that you use on weekends, in the evenings at home. There's a risk for expansion in other areas. But to go back to the Fulton case, there were echoes of this in a lot of the, COVID restriction cases too, right? This idea that I think Roberts is sort of slowly building this sort of new jurisprudence of, if you have any exceptions to a law, and if you can make any kind of analogy between who gets an exception and a religious organization, then the religious organization also has to get clothed with that exception. And so I think there's a through line there. I think it was Tom Goldstein who called it sort of most favored nation status,
right?
Which I think is building, and I think it will eventually go where some of the more bold conservatives or more activist conservatives want to go, but it's going to do so more slowly. And in a way that might be more stable than overturning the precedent of Oregon v. Smith. I do find it really intriguing that, Oregon v. Smith was a huge change when it came down, written by Scalia. And
can you explain what that is for folks who, unless they stop and Google it if they don't know?
Right.
Then...
Sorry. I'm not as good at this as Nancy is, but in Oregon v. Smith, which I think was what, 1990, 1991, Nancy?
Yeah, I think it was 90.
90.
I think it was 90, yeah.
It was a case out of Oregon, of course, where you had a couple of drug counselors who were fired from their position because they had ingested peyote during a religious ceremony, a Native American religious ceremony, and they wanted unemployment benefits. And the state had denied it to them because they were fired for cause. And they brought a challenge saying, well, you know, you're denying me my unemployment benefits because I was practicing my religion. Now, under the current precedent before this case, the state would have had to pass, you know, the highest hurdle of free speech and free exercise jurisprudence called strict scrutiny. They would have had to show that they had a compelling interest in the denial. They were using the least restrictive means. And previously, states had not been able to do this for unemployment benefits. The previous cases usually dealt with people who would not take work on Saturdays because that was their Sabbath. And the court had said, no, you can't deny someone unemployment benefits. You can't punish them for practicing their religion. In this case, Scalia says, well, and kind of takes a turn back in jurisprudence back before that application of strict scrutiny and that sort of protection for religion, and says, well, if a law is neutrally applicable, a generally applicable law, then the state doesn't have to pass strict scrutiny. And so a drug law that says no one can ingest peyote is not targeting religion. Therefore, the state can have that law. And these gentlemen were not allowed to have their unemployment benefits. So as long as the state isn't targeting religion, if there's sort of an impact on religion that's secondary, that's not going to trigger this high level of scrutiny. That was, you know, lauded, and because it gave a lot of protection for laws that disallowed drug use and didn't allow you to use a religious claim to allow drug use and such. And so this was supported, I think, generally. I don't think anyone in the conservative movement was anti-Smith, anti that doctrine, until generally applicable laws seemed to start to impact major religions. So when you weren't talking about Jehovah's Witnesses or Seventh-day Adventists not getting unemployment insurance because they didn't want to work on Saturday, or Native Americans using peyote in a Native American rite. But suddenly now with anti-discrimination laws, including same-sex couples or sexual orientation, now you had, you know, Catholic religions and other Christian religions that didn't recognize those lifestyles being affected by these anti-discrimination laws. And suddenly Oregon v. Smith is not such a great precedent anymore. And you start to see this movement to try to get rid of Oregon v. Smith. And that's what Alito is talking about in the dissent, is that it was time to get rid of Oregon v. Smith and just subject states, when they place anti-discrimination laws on the books, you know, in hiring practices, in contracting practices, to that strict scrutiny where they won't really be able to pass it. And then there'll be essentially an exemption for free exercise around anti-discrimination laws. Was that simplified enough?
That was, I was going to see if Nancy had anything to add. Otherwise,
she'll say it much better than I.
No, I think my colleague has done a superb job. And I would say that one needs to reflect on whether the religion that is affected is the critical factor that explains the difference. You know, the creation of the higher level of protection for religious free exercise, which takes place under the Warren Court,
right,
was to protect minority faiths and
yep.
faiths that were often, now I can use the word vilified, hated in their communities and persecuted in their communities, such as Jehovah's Witnesses.
Absolutely.
And so what the Warren Court was doing was setting up a civil libertarian standard to protect people who are not part of the majority religion, whose religion is not automatically protected by the state, as Christianity, has many holidays that are state holidays. And so, the difference between a small, unusual set of practices in a faith and a majority faith, quite different. And so what the Warren Court was trying to do was say, these kind of religious minorities require a special attention to the possibility of persecution by the state. And so that's why the strict scrutiny standard came about in the first place. When the Rehnquist court altered that direction, it was in this case that was kind of complicated by the war on drugs ideology, and it was, in another sense, perhaps a signal that the Rehnquist court wasn't going to be as solicitous and concerned about minority religious practices. They might have to tolerate accommodating, what the majority sentiment was on some public policy question. But
Right.
Rorie's exactly right. What has been happening more recently is that mainstream Christian faith denominations, Catholics, etc., mainline Protestant denominations are suggesting that they too should have this most exacting scrutiny and highest level of protection, when in fact they're not exactly in the same situation as a persecuted minority faith, but they're trying to analogize constitutionally their position to these older cases that involved Amish and Sabbatarians and things like that. And I do think they are finding a receptive ear. And there's quite an armada of legal interest organizations that bring cases on behalf of religious freedom questions and the idea of expanding religious freedom. And I think all of these organizations, these litigants, these actors know they have a receptive ear in the Roberts Court. And so, dismantling the Smith approach, also, Congress has taken a hand there too with the Religious Freedom Restoration Act, which of course only affects things that the federal government does. But I think there was some pushback to the narrowing of religious freedom that has been building in the conservative movement. But what has really brought it to a head, and Rorie's absolutely right, is this conflict over lifestyle questions between, the religiously observant who hold certain views, mostly about sexuality-related issues, and the, larger political culture move towards greater protection against discrimination on the basis.
Well, not to mention abortion.
Yeah.
Right, but
Yes.
abortion wouldn't really be part of this part of the conversation.
But we probably should talk about it, I suppose.
We should, but right.
Yeah.
I just think it's important to note that when we talk about those initial cases, as Nancy said, it was with, minority religions. So you were fighting to be able to have not be required by the state to work on a Saturday, when what the protection that Nancy's talking about is because no one was required to work on Sunday, right? So. Right. This was, already baked into law was the protection for the majority religions, the majority Christian and Catholic religions for their Sabbath, right? So that was where the Warren Court was looking at this and saying, well, you can't, have that, we need to also have the protection for others. Now we're looking, again, we can go to the COVID cases and then, of course, the Fulton case and look at this idea that, well, we can't have a public health law that restricts free exercise of religion, right? And so it starts really there with this idea that if there's any exception, or if you can make any analogy, as they did in that one case, I'm not going to remember the name, I think it was the one out of California, where it's like, well, Home Depot can be open, therefore churches have to be open. Right. And I think it was Sotomayor who said, these two places are not analogous in terms of the activities, but In the majority, they said, yes, they are. And you see that same kind of language in Fulton sort of saying, well, even though Philadelphia hadn't granted an exception to anybody, they allowed an exception to the law. And therefore, if there's an exception allowed, then religion must be able to also be accommodated.
Indeed, we have to also mention the case related to COVID restrictions, which also has to do with religious liberty. And this was the Roman Catholic Diocese of Brooklyn versus Cuomo. And here you have, at least surprisingly to some, Roberts in the dissent. It's 5-4 with the conservatives, but Roberts joins the liberals. The court ruled that New York could not prohibit in-person attendance at worship services because it violated the Constitution's protection of religious liberty. What's Roberts doing over there on the liberal side of things?
Yeah. Well, and I think we want to really be clear that we talk about the court with this binary of liberal versus conservative. But any one decision, even if the liberals are on that side, whether it's a truly liberal decision or if it's just kind of over the line, right?
Well, it could be 0.1% left of center, and we're calling it liberal.
And then people are like, look, he's on the liberal side. And I think we want to be...
Until we come up with a better one-word descriptor of that.
But it is a long spectrum. And I think, when we start talking about the liberals on this court, I do like to do this thing for my students where I'll take those liberal versus conservative scores and sort of put the justices on the ideological line there, and then add justices who are sort of icons of liberalness, and sort of show them exactly how far the current liberal justices are from, say, Marshall or Warren, just so they can get a sense of the stretch. Because I think that always puts things in perspective that, our liberals today would probably, if we sort of time, Bill and Ted's Excellent Adventure and took them back to the 1950s in the Warren Court, they would be conservatives.
They'd be like Potter Stewarts or something.
Yeah.
Well, when I say liberal, I'm not implying that Chief Justice Roberts is Bernie Sanders, to be clear.
Right. I know that we know what we mean, but a lot of people who hear this start to think, oh, he's turning liberal or he's changed. I remember this a lot with Justice Kennedy, right, where they were, he was on the 5-4 on the liberal side in several cases, and suddenly everyone's like, oh, Kennedy will save us. I'm like, no.
Okay, but you brought up an interesting point. You brought up an interesting point, Rorie Solberg. Your basic point is that the people considered on the left of the court today 50 years ago would not be considered on the left of the court then. What's happened? Nancy and I have talked about this before, but it's interesting to get another perspective and see is it a shift rightward? Is that all it is? Or has the left moved right and the centers stayed the same and the right stayed the same? Or has it all moved right?
Well, I mean, the appointments to the court have pretty much moved right? If you look from the predecessor to the successor, in every instance since the 1970s, we've been moving to the right. I think it's partially who's been president and partially the Senate and the ability of the Republicans to play the strategic game in terms of judicial appointments much, much better than the Democrats. And so who you can get on the court, right? So you think about Bill Clinton, he was a centrist and he appointed centrist justices. He didn't appoint extremely liberal justices. Then you get Obama, and who can he get through, right? And I think Merrick Garland is the perfect case. You couldn't look for somebody who was more palatable to both sides. He was about as the best you could hope for as a Republican to get from a Democratic president, and they just said no, right? So who you can get on the court is also part of this. So that the politics and the polarization that's happened there.
Well, it didn't matter who Obama would have nominated. The answer would have been no. He could have,
right, but he was extremely strategic in going for Garland. I mean, he put up, someone who ostensibly should have been like, you should have had some Republicans who say, well, this is pretty good from a liberal president.
Strategic, except that he didn't even get a hearing, so I'm not sure how strategic successfully
but I mean,
that was.
I'm saying he made the effort,
He made an effort that was for naught.
That was for naught, right? Which, and I think in some, history will show that, this game has now changed dramatically at that point. That, the Bork hearing was sort of watershed, and I think the Garland situation, the Garland Gorsuch with the demise of the filibuster for Supreme Court nominees will be a watershed, and we might, whether we'll see a change in the appointment strategies of Democrat presidents remains to be seen, because of course they haven't had that opportunity in the new era. We'll see if they've learned, essentially, I guess.
Nancy, anything to add here?
Well, I mean, as we're talking about this, of course, it makes us all think of the situation involving Stephen Breyer.
Yeah.
And, the pressure being exerted, from some aspects of, the Democratic coalition, maybe the more progressive wing of that coalition, to urge him to step down so that the seat could be filled by Mr. Biden
and Joe Manchin.
Yeah, well, and so that a younger Democrat appointed justice could be placed on the court to kind of preserve the seat, as it were. And the pressure is, of course, that Biden could only really count on getting his person confirmed while the Democrats control the Senate, which they do very, very narrowly, right? And so by waiting until after the midterm elections, the potential for risk is high that, the president would lose that strategic opportunity. And what if, God forbid, poor Stephen Breyer has a fatal episode? Again, it suggests what Rorie's talking about, that Democratic presidents have found their options limited and have increasingly, had to go with more moderate or modified appointees. And this is partly what explains the difference between the liberal wing now and the liberal justices of the past. I would say there's probably only one of them that could really count as a liberal justice. That would probably be Sotomayor. I mean, Breyer is a pragmatist. And what I'm sort of interested to see is, okay, he's staying on the court. I think he got a little bit annoyed with the pressure put on him. I think
and rightfully so, I think, because first of all, he's not 102.
No.
He's extraordinarily
82,
healthy.
Extraordinarily healthy, mentally and physically.
And no one's going to appreciate, a billboard truck driving around your workplace saying retire.
And not just that, but Ruth Bader Ginsburg she was somewhat older, but she'd also been in and out of the hospital for years and years and years, and was very ill on and off over the course of, 15 to 20 years. As far as anybody knows, he's not sort of having secret cancer treatment. So I can see why Justice Breyer, who, by the way, I met in Aspen and performed solo Bach for, and there's a great picture of he and I floating around together. He was a music fan, not as much as RBG, but who I also played for and met and have pictures with. But in any case, Stephen Breyer loved my Bach, so I like him.
Okay.
Okay.
But, Daniel, what I was also going to say about Breyer is he's a noted pragmatist. I mean, that's kind of the approach he takes jurisprudentially. I wonder if he doesn't see the opportunity for some great challenges ahead to work with some of the new conservatives, particularly Amy Coney Barrett, who has written fairly extensively on what she calls a pragmatic approach to originalism. I wonder if Breyer doesn't see, because he's an intellectual, Stephen Breyer, I wonder if he doesn't see an opportunity for some really important conversations around interpretation that he could be very central to. And Kagan, I think, is also a pragmatic-oriented justice, making her less of an iconic liberal. And, they have the potential to work with some of those more incrementally oriented conservatives that we were talking about. And that's, I think, what Breyer sees ahead and why he's resistant to the pressure, notwithstanding that it's just irritating to have to receive it in the first place. But I think he sees that there's something for him to do and accomplish And he really is well placed to do that.
How old is the tradition of the public pressuring justices to resign? To me, it seems a little newfangled. Is it? There's a long, grand old tradition in the United States of people getting restless. He's getting too old. Let's get him out of here.
Well, of course, people used to just die. They used to just drop dead.
Yeah.
People didn't live as long. And so the pressure to retire, well, I don't know. Does it go all the way back to Chief Justice Marshall? I mean, I'm sure he was an irritant for many years for Thomas Jefferson, but couldn't do too much about it. And he hung on a good long time.
I mean, there's always sort of a watch at the end of the term. And I think back to something that Justice Stevens said, that when he retired was that he probably wouldn't have held on as long if the court was still, doing what they did during the Berger court, which was hearing 250 cases a term, right? When the court is only hearing 54 cases, right? The workload is not such that it's going to perhaps be too much for someone as they reach, octogenarian status, particularly someone with the intellect and the drive of a Supreme Court justice. So, there might be some kind of interactive effect with the idea that, well, the workload is doable at that level, at that age, versus a really a heavier course load. And we see the court, since Rehnquist taking fewer and fewer cases. I think it was, again, people talk about the percentage of unanimous cases. And like, they only heard 54 cases this term. So, even if the percentage was high, the total number of unanimous cases is not very large in that absolute number.
Interesting to note. Okay, now before we go and have a little preview of the future of what's to come, maybe some notable cases you want to keep your eye on or something like that, there was some of the smaller cases that didn't receive so much attention were quite interesting. The one that I think I didn't see a ton about in the news was the TransUnion LLC versus Ramirez. And this is a very interesting case in which basically a man goes into a Nissan dealership in California. He to buy a car, he negotiates the price, and then the dealership runs a credit check through this company called TransUnion. And the report comes back and says his name matched one on a Treasury Department watch list of drug traffickers, other criminals, and terrorists. And in this ruling, the Supreme Court limited the scope of a class action lawsuit. Okay, so it's maybe not the biggest case in the world, but it is interesting to note that it's a rather generic name, Sergio Ramirez. One can imagine there's thousands and thousands in the United States. And this company, TransUnion, says that this name is a match to a terrorist list or a list of criminals. And in fact, he represented more than 8,000 people whose credit reports included misleading information. It's rather striking, isn't it, to you too, when you think about an act as innocent as going to a car dealership, try to buy a car.
Have you bought a car recently, Daniel? Is that why you're focused on this one?
No, I bought one last summer, but my name is rather unusual, so I don't think there are Daniel Lelchuk showing up on terrorism lists.
Here's just a general reaction, I would say.
Yeah.
Another trend that many commentators observe about the Roberts bench is a tendency to want to limit access to court, limit devices that allow people to get into court or use courts to seek redress. And so limiting the scope of a class action provision or limiting class action opportunities, limiting provision of attorney fees, standing. These are all methods of curtailing access or curtailing the openness of the judicial realm to remedy policy problems, complaints of that have policy implications. And so that would be kind of my reaction to the case, just off the cuff.
And I would tag on to what Nancy said and flip it back to one of those cases that was bigger that we haven't talked about, which is the Arizona voting rights case. which you see the same kind of decision where the court is essentially saying we're not going to allow essentially disparate impact claims under Section 2 of the Voting Rights, which is going to narrow the number of claims that can come dramatically so under Section 2 of the Voting Rights Act. And so again, restricting access to court redress for groups that feel aggrieved under federal law. So you can sort of tag this very large case that most people have heard about if they've been following the court at all with this smaller case that you bring up, or less blockbuster case, I guess.
I'm sure it wasn't a small case to Mr. Ramirez, right?
Or to the 8,000 people who were in the class action, where I think it's almost 6,500 of them were then, no, you don't get to be part of this class action. So they're all out. So you have that same kind of idea of saying, no, the law is not the way that you're going to get redress here. And that it's a very small c conservative view of just this idea that the law doesn't provide an answer to every problem. And we're not going to read the law in such an expansive way as to allow it to answer every problem or every harm that we might perceive. And I think that's a really important. I think Nancy should add that to her from her 2 directions of this court. She should add it, make it a 3 directions, and sort of go back to and add that here as you know, and that's really, I would say, part and parcel of originalism, right? Originalism, and Scalia would often say this, and you know, as sort of an icon of originalism, that the law doesn't provide you with an answer for every harm, right? The law is only does what it says it can do. So I did want to at least get us a little bit into that Arizona voting rights case, because I think it's really important, and I think shows that the court is just on a completely different track in terms of understanding of discrimination, or what they'll allow as discrimination, than a lot of the literature and the scholarship in terms of what we know about discrimination and how it intersects with laws and government. And it just it's one of those cases where I think the reverberation is going to be even bigger than people think. It's clearly going to affect voting rights cases and allow states to restrict voting in what is perceived as neutral ways. But it also just shows that the court has, at least a majority of the court, really is keeping to this fiction that discrimination really only happens when it's overt and it's intentional, and there's nothing implicit involved. And, you know, writing a law that says, if we go back to our religious case discussion, that says, you know, Sunday is excluded, and how that, you know, there's no recognition that that's a sort of a baked in advantage or a baked in benefit for people who subscribe to the major religions, who tend to have their Sabbath on Sunday, right? That part of the law does create a disparate impact. And they're moving away from that kind of view and moving towards this idea that, no, you would have to say, we don't allow religious exceptions for Saturday Sabbaths. You have to be that clear about it. And we know the law just isn't that clear.
And by major religions, you mean Christianity? Because
I mean Christianity. Yeah. I mean, there was a case back in the 1960s about a Jewish man and the Sunday closing laws. And the court was like, well, no, it's perfectly legitimate for the state to say we need a day of rest. And it just happens to be Sunday, right? Just eliding, you know, even the Warren Court just eliding the idea that there's a particular reason why the people who write the laws, who are a majority Christian religion, decided that Sunday would be the best day instead of, say, Wednesday. Right.
If we could look toward the future, the immediate future, now we're in summer 2021. The term has ended, but it's going to restart soon. First of all, when does it officially start again? And what cases are going to be contentious? What are you going to look toward? What should we be researching and reading up on between now and then?
Okay, well, I'll take the when does it start again, right? The justices will meet at the end of September for their large conference, and then the session will open in October. It always opens in October of every year, and that will start October term 2021, which by all accounts could be a very big term. But to continue other parts of our conversation when we talked about how Roberts tends to narrow things and write these sort of technical opinions that maybe don't go as far as we thought, Fulton being the example here. While they've docketed a case on abortion, on gun rights, on religious school funding, whether those opinions come down in a way that makes for big changes in the law uh, is really going to depend on who writes the opinion and how far they want to go. I think we've seen so far that Roberts has been a little gun shy in terms of the abortion question to move forward to completely dismantling Roe versus Wade. So I don't think that's out of the realm of possibility, but I think it's going to continue to be this extraordinarily incremental chipping away at access to abortion in the name of women's health that we've seen in, say, June Medical and those sorts of things. Although Roberts was on the dissenting side in that decision, and so it might come down as a 5-4 and go further, given the proclivities of Thomas, Alito, and what we think we know about Barrett. I'll throw it over to Nancy to talk about any of the other things happening.
What do we look towards? To illuminate the future.
Well, I mean, I think the two cases that are, going to be argued that have probably gotten the most attention are the case coming out of Mississippi that involves a more restrictive abortion law that limits abortion to a very narrow window of time, much narrower than had been previously acceptable under the Planned Parenthood versus Casey approach, the undue burden approach, et cetera. And, the opportunity there is for the court to just simply keep retracting further and further while still applying the precedent of Casey without revisiting the entire apparatus of privacy and reproductive choice. So that's gotten a lot of attention. And of course, we are all going to be paying attention to that case because it picks up on the many things we've been discussing, including the cleavages within the conservative bloc. And then the other case that's gotten the most attention, that docketed, is the case out of New York that involves potentially an expansion of Second Amendment rights to extend now beyond the home and the idea of self-defense, which is where the court had really rooted the idea of the right to own a firearm. And Kennedy was instrumental here in creating this idea that the right to self-defense is an individual right, but it has a certain context to it, which is to defend one's life and one's family from invasion of one's sacred space, the home. Well, the case out of New York is going to ask, should this be expanded to kind of a roving self-defense that would include an individual being able to challenge a concealed carry law or a permitting law that restricts the ability to bring a firearm out into public for the purposes of individual security. So, there the opportunity is for the court to, again, incrementally expand what it has already done. But there really have not been any significant gun rights cases to the Supreme Court for quite a while. It has been percolating at the lower court level. And so, we're going to see potentially a statement of clarification in one direction or another. And I don't know, I have a feeling the conservatives are a bit more unified around the Second Amendment issue than they might be on the overturning Roe issue.
Yeah, I think that the gun case is going to be extremely important because we haven't had a statement since McDonald v. Chicago that said, the Second Amendment also applies to the states. The third case that's gotten a lot of attention has been the case out of Maine dealing with the public funding of private high school education.
Mm-hmm.
And in this case, you've got, Maine provides support for students who live in a school district that doesn't have, schools or doesn't have their own high school to go to another high school or attend a private school. But they've always restricted this to exclude religious schools. And so we're going to see that same kind of clash that we saw, again, in the COVID cases, in the Philadelphia case, right, of can the state make an exclusion from religion? So it's this sort of clash between the state saying, well, we don't want to support religion against the Establishment Clause, but that then places a burden potentially on the exercise of religion of those schools or of those students who would like to attend that school.
Well, exactly, because the Maine Department of Education policy states that public tuition dollars for families who don't live near a public school, because we're talking about a very large, very rural state.
Right.
So this probably happens a lot. The families who don't live near a public school, the monies from the state cannot be used to send students to religious schools, but can be used to send them to public or private schools.
Right. And I think the court is going to use this case to go even farther than they did, I think, in the Montana suit from a couple of years ago, where Montana wouldn't provide a grant to a church to, essentially to upgrade their playground for their religious school. And I'm pretty sure it was Montana said, they said, well, our state constitution says we cannot fund religion, right? So it wasn't even just the First Amendment, it was the state constitution. And the court said, no, that all falls to the free exercise claim. So I think that's going to be a very important case that's going to line up with the Fulton case in this kind of challenge towards, creating, again, as Tom Goldstein said, this most favored nation status for free exercise claims. The only other case that I think has gotten a lot of attention so far is the affirmative action case, but it's not clear at this point whether they will actually hear that next year, because I think that the court has actually asked for the Biden administration's views, so asked for a brief from the Solicitor General, and that's going to take some time and allow them to kind of stretch that one out. I'm not sure they want to tackle that one in the same term as maybe these others.
Well, it's very interesting, and obviously there's a lot to reflect on, and from the big, the blockbuster and the less blockbuster cases, and these alliances and all the stuff we've covered. Obviously, the themes, though, remain the same. The religious themes, a single voter issue, the biggest of which is abortion, obviously. Religious freedom, freedom of speech, guns. It's the same old story, but we're gonna
Right.
we're gonna have a lot more coming down, obviously. So hopefully we'll be able to do this again. And it's great to talk to you both, Rorie Solberg and Nancy Maveety. Thank you.
Thank you for having me again. This was fun.
Thank you, Daniel. Yes, I'm sure we'll have more material coming our way.
Yeah, we have to particularly watch Justice Barrett to see what happens after her first term.
We'll be watching her. We'll see if Justice Breyer goes anywhere, if he bows to the pressure of the trucks driving around with the billboards. And meanwhile, we wish you well and thank you.
You've been listening to Talking Beats with Daniel Elchuk. The original theme music is by Ronald Barkham. The content coordinator is Nathaniel Mosey, and Doug Christian is executive producer. We invite you to subscribe and leave a 5-star review on Apple, Spotify, or anywhere you get your podcasts. You can support us at patreon.com/talkingbeats. That's patreon.com/talkingbeats. And be sure to check us out on social media. We'll see you next time on Talking Beats with Daniel Elchuk.